Next, Suzanne Morphew, right? We talked about the autopsy that was returned yesterday, or made public, I guess would be a more accurate statement, since it was done back in September of 2023, but just released yesterday. But what we do know is after Suzanne Morphew's body was found back in September of 2023, years after she allegedly went on this Mother's Day bike ride back in 2020, obviously never returned. Now, investigators have confirmed that she was the victim of a homicide, and opioid and sedatives were found in her system. Now, when Suzanne Morphew did not return home, the investigators focused primarily on her husband, Barry Morphew, as a murder suspect. But that case got dismissed when it fell apart, when the prosecution failed to turn over exculpatory evidence to the defense. Now, remember, the prosecution always has a duty to turn over exculpatory evidence, and the judge described this prosecution's office's failure as egregious. What was it that they didn't do? Well, they failed to mention, even though they knew it months even before Barry Morphew was charged, that an unknown male's DNA, which turned up in a CODIS hit, that's the national database for bad guys, and that's maintained by the FBI, was linked to sexual assaults in Chicago, Illinois, as well as Phoenix and Tempe, Arizona. So does that mean that the man whose DNA was linked to multiple unsolved sexual assaults maybe has a pattern that involves drugging victims? Maybe an opportunity where 404B evidence may come in. So was Suzanne Morphew, originally drugged, assaulted, and then murdered by this unknown identified man through DNA? Was there a firearm involved, because a bullet was apparently found near the body? And where is this individual right now? Should we be worried, concerned? Is this person in custody as of right now? But where was he back on Mother's Day of 2020? Interesting indeed. So as you all may also recall, Barry Morphew sued the prosecutors and investigators in this case because they knew 5 months before Morphew was arrested, but didn't disclose that this serial sexual assault suspect's DNA was found on various items of the crime scene. Like I said, the interior cushion of the bike helmet, Mrs. Morphew's bike, the glove box and back seat of Mrs. Morphew's Range Rover. Now, Barry Morphew alleges that the state kept that hidden in his lawsuit, and that it irreparably tarnished his name all across America by accusing him of murdering his wife over an affair and a failing marriage. Now, the Morphew family made a statement, as you may recall. Suzanne and Barry Morphew's daughters stood behind Barry throughout, and they continue to. Anyway, they made a statement that says the autopsy confirms that Suzanne was abducted, allegedly drugged, and buried 50 miles south of their home. The DNA left on the clothing by the murderer could bring justice for Suzanne, her family, and the community. The statement also said that it raises many questions about testing of a bullet in evidence. The authorities will also not provide the Morphews any information regarding whether they have performed any testing on the bullet that was collected from Suzanne's remains. So Barry, Mallory, and Macy, the two daughters, were given the option of retrieving Suzanne remains, but they want to ensure the suspect is apprehended before they do that, because it could be an important part of the evidence, and obviously the defense may want to have their own independent expert evaluate those skeletal remains. The Richard Allen case, the Delphi case. Something is not right here, ladies and gentlemen. I understand that Judge Francis C. Gull has some animosity towards the defense attorneys for Richard Allen, but this is getting a little out of hand. So let's get to it. So the defense team for Richard Allen in the Delphi murder case has told the judge that the trial could go past when it was scheduled to last. As you may recall, the judge basically said, I'm giving you all 2 weeks. And Richard Allen is accused of killing Libby German and Abby Williams back in 2017. And the trial was scheduled to go from May 13th through May 31st. Now, the attorneys argued that the prosecution had previously said that they had 118 witnesses and roughly 93 exhibits. The defense said that that's sheer scope of all those witnesses could last the scheduled trial time. Now, the defense said its side of the case would take a couple of weeks to present and that it had 70 witnesses to call. The defense also points to challenges with Mr. Allen needing to be transported to and from the courthouse each day, and that the same is true with the sequestered jurors. Now, the defense stated, quote, "The court's approach to such a rigid trial schedule infringing upon defendant Allen's Sixth Amendment right and underscores the need for the court to conduct scheduling hearings regarding the trial. The defense argues there should be a pretrial hearing to discuss how long the trial should last. But the judge responded in an email to all counsel, and this email went out in April, end of April, April 28th, and it said, Judge Gall says jury selection should last 3 days. She said the defense were the ones who requested a speedy trial, and the trial date is the length of the trial. No more, no less. Gall said, well, no attorneys had notified the court when the trial dates were set that they needed more time. She also said that she has tried a death penalty and life without parole cases with multiple victims in the past in the same time allotted. Gall then takes aim at the defense attorneys looking to identify other potential suspects, saying, oh, by the way, I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. Now, Judge Francis C. Gall goes on to say that the defense should be prepared to present the case in a timely way and have its witnesses available to appear quite quickly. She said the defense should not time witnesses poorly and have respect for the time of the jurors. So, ladies and gentlemen, this judge, Francis C. Gall, I mean, we've all dealt in the legal system with difficult judges that want a rocket docket. But this judge is going out of her way to make life miserable for the defense attorneys. And what she is potentially doing here is setting up a redo, okay? She has yet to have any sort of substantive hearing on any of the motions. She has denied every motion outright. And before the defense has put forth any evidence, she's already saying basically your defense of some alternate suspect is not going to be permitted, so don't even plan on calling those witnesses. Now, yes, normally you must show some nexus when you're saying an alternate suspect. If you're pointing the finger at another suspect, you have to show that they had kind of the motive, the opportunity, they were in the area, and that they followed sort of a modus operandi. Now, that may be a little tough for the defense. I'm not going to say that they got this clearly, but the defendant has a constitutional right to present a defense in their case. And when the judge prevents them from presenting that defense, guess what? You are setting up huge appellate issues. And listen, there's no way, I don't care how quick prosecution witnesses are, if they have 118 endorsed witnesses, there's no way that they're going to do that. The last trial that I just did that went into 4 weeks, we had 32 witnesses just on the prosecution side. 4 weeks, ladies and gentlemen. So for this judge to say this is all the time you have, unbelievable. I've only seen that once where the court said we have 2 weeks. It was a federal trial. The judge thought, no, we're going to get this thing done. And he said, listen, prosecution, you have 2 weeks. You can have basically 7 days. The rest is for the defense, closings, and deliberations, basically. That was the only time I've ever seen that imposed, and the government said, well, if that's all we got, we'll pare it down and we'll do what we have to do. I don't see them making that same request here for the prosecution to pare down their witnesses. And frankly, it would be an automatic reversal if somehow she didn't allow the defense to present a case if they have witnesses, because the court has run out of time. What the court is really trying to do here is say, Well, Mr. Defense Attorneys, Mr. Smarty Pants, you demanded a speedy trial. How are we going to get this done? This is what we allotted for the trial. You should have made me aware of this. Oh, are you now saying that you would like to waive Mr. Allen's speedy trial rights and set this out so that we can schedule it for more time? Kind of seems like what the judge is trying to do here. The next issue in the Richard Allen case is now the defense is saying that there is new phone evidence from the hours surrounding the death, which could shed a little more light on the case. Now, there's been a flurry of pleadings filed in this case, and some of these pleadings filed on Tuesday request for a fourth time that a search warrant of Mr. Allen's home be thrown out, arguing that there have been delays in the prosecutors turning over this evidence. The defense also claimed in the filings that it received information on April 26 regarding the whereabouts of Libby's cell phone when she went missing with Abby on February 13th of 2017. And in their latest request for a hearing on the search warrant, the defense team has said that the Indiana State Police troopers received information on the location of Libby's phone from AT&T, and the girl's phone had connected to a cell tower near the Monon High Bridge Trail in Delphi, Indiana on the day they vanished. The device is said to have stopped pinging at 5:44 p.m. So Allen's defense team is saying that the police believe the information which they were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in a working condition. However, the phone made contact with a tower once more at 4:33 a.m. on February 14th. So, obviously, we know the girls' bodies were found roughly 8 hours later, and the defense team for Mr. Allen claims that the phone and the girls had left the woods near the trail, arguing the timeline doesn't line up with the 90-minute window prosecutors allege that Mr. Allen was there at the trail. Now, this could be somewhat important because this juncture, Richard Allen is the only person charged. And if Richard Allen is the only one alleged to have committed the crime at all, he's not charged under a theory of conspiracy or complicity. And we haven't heard of any potential other suspects. So the plot thickens. So according to what we do know from some various filings was that Libby's phone was found under her shoe. And according to the defense, if Allen killed the girls, the phone should have never moved after the murder and shouldn't have lost contact with the cell tower for 11 hours. It's also been alleged that Mr. Allen confessed to the killings multiple times since he's been behind bars. And in a phone call back on April 3rd of 2023 between Allen and his wife, Kathy, it's alleged that Mr. Allen told his wife that he confessed to committing the murders at least 5 times. Now, his wife, Kathy, upon allegedly hearing that, ends the phone call and hangs up rather abruptly. Now, as you may recall, police had also been investigating a guy by the name of Ron Logan after the bodies of Abby and Libby were found 1,400 feet from his home. And it was initially believed that Logan matched the appearance of a man in a Snapchat video taken by the girls. However, after being questioned by investigators, it was determined that Logan wasn't involved in the murders and no charges were filed against him. Now, Logan later died in January of 2022, but it gets even weirder because his ex-girlfriend, Connie Dillman, alleged that her former lover, boyfriend, was the killer. She says, "That's your voice," she's referring to as a video taken by Abby and Libby that shows the man in the blue jacket saying "down the hill." She said, quote, "I heard the voice of down the hill thousands of times. That is Ron Logan," Miss Dillman said. So the plot thickens, ladies and gentlemen. It's going to be tricky here to see if the defense can pull this off without a continuance, and if the prosecution can do this in the 2 weeks allotted. Seems unlikely. And then on top of that, you've got a judge that has absolute contempt for the defense in this case if she is going to be able to rein in that contempt and at least present a fair trial. I guess we know why she doesn't want this trial televised, because it's kind of looking like the fix is in. I don't know if Mr. Allen did it. I don't know if he confessed, but I'd sure like to see it to make up my own mind instead of having the judge keep us out of the trial of one of the biggest trials, not only in the state of Indiana, but in the country in a very long time. We'll follow up. In fact, those pleadings are so interesting. My little summary probably didn't do him justice. I may do just a separate podcast just of those pleadings. Next, the Chad Daybell trial. Yeah, apparently Mr. Pryor didn't want the world to know what we already knew, which is that he owned Chad Daybell's house. In the trial of Chad Daybell last Friday, a neighbor of Chad and Tammy Daybell, a guy by the name of Ron Arnold, he's a realtor, came to testify. And during the cross-examination conducted by Mr. John Pryor, it became somewhat heated regarding questions related to the home. Let's go to the relevant portion of the transcript, please. Pryor: you're familiar with Chad Daybell's house, right? Arnold: no, I've never been inside that house. I've been in the foyer. They have a breezeway or an entryway, and that's as far as I've ever been in that house. Pryor: did you familiarize yourself with the property surrounding that house? Arnold: when we talked about splitting the property, it was about the acreage, not about the house or floor plan or those kinds of things. Pryor: okay. So the acreage that you're talking about, do you have any recollection of how much acreage we're talking about that surrounds Chad's house? Arnold: you own it. How many acres is it? Pryor: well, I don't know. Pryor then asked for a sidebar, and Judge Boyce instructed the jurors to disregard Arnold's statement that Mr. Pryor now owns the house, and no one should speculate about that during deliberations. The judge then admonished Mr. Arnold to stay away from the topic in any future questioning. Now, as we all know, the property of Chad Daybell is owned by Mr. Pryor. It's called being paid for your legal fees. And that took place back in May of 2021, which is roughly about the same time that Pryor was hired to take on Chad Daybell's case. And now, we can't take homes where I practice law for payment. It'd be great. I'd be a great landlord. But attorneys got in trouble for that years and years ago because they would take a lien on the house. And obviously, you can't take something that you haven't earned yet, so you would have a lien. Client would then get convicted, go to prison. The attorney would then foreclose on the house. And people argued, well, I don't think he did a good job for me because he didn't want to do a good job for me. He just wanted my house. So they made that unethical, at least where I practice law. I don't think I would take a house unless all legal fees were in fact done, and then therefore you can say that it's been earned. But otherwise, taking property like that gets a little unethical, but it's a big case. I'm sure Mr. Pryor has earned it by now. Now, in today's testimony, an FBI agent testified regarding the cell phones, and it was pretty typical stuff that they were tracing Mr. Chad Daybell's cell phone to various parts of the property, being at Alex Cox's apartment on the night in question, as well as explaining how they go about tracking cell phones. Not people, but cell phones. Remember that, ladies and gentlemen. Anyway, it was not a long cross-examination today by Mr. Pryor on that issue. And one of the questions, the old adage, don't ever ask a question you don't know the answer to. When Mr. Pryor said, well, a civilian couldn't go out and recreate this, the guy was like, no, you could. You just need to buy the various antennas and things like that. So sometimes you just don't go there if you don't know the answer. Next. Yes, Delphi. Special Judge Francis C. Gull has found the defense attorneys for Richard Allen, yes, the Delphi homicide suspect. She states that they were sloppy, negligent, and incompetent. But she declined to hold the pair in contempt. Who said that? Who said she didn't think she was going to find him in contempt? And if there were, it would probably be after the trial. But anyway, I can't wait for this trial, ladies and gentlemen, when the judge thinks that you are a walking, incompetent, bumbling boob. And she says, as we brought you the story yesterday, that your alternate suspect defense isn't going to fly. And we'll probably get this trial done in 2 weeks. I can't wait for this trial. I just wish that it was televised, Judge Gull. So anyway, let's get to the heart of it. So Judge Gull's order is in regards to the March 18th hearing where the Carroll County prosecutor, Nicholas McClellan, filed a motion to hold the defense attorneys, Andrew Baldwin and Bradley Rozzi, in contempt, saying that they had leaked evidence, and that evidence came back to the attorneys, and he also said that the attorneys violated the gag order. So the attorneys, Rozzi and Baldwin, they represent Richard Allen, obviously accused of killing Abby Williams and Libby German near the Monon High Bridge in Delphi 7 years ago. Now, Rozzi and Baldwin were originally thrown off the case by Judge Frances Seagull because she thought that they were incompetent, committed malpractice, and basically shouldn't be practicing law. We've talked about this on numerous shows, so we won't go through it all over again, but Bradley and Rozzi appealed to the Indiana Supreme Court, and the Indiana Supreme Court said, hey, if Mr. Allen wants these two attorneys that are supposedly incompetent boobs, they can certainly do so, and it's not the judge's right to protect the defendant from his own choices. I get it. But these guys have about 70 years of criminal defense experience between them. They were originally appointed because they were experienced criminal defense attorneys, and now they're going out there doing their job for Mr. Allen, and they've been criticized. The whole thing about, somebody that you trust, a former employee, goes into a room and takes photograph of pictures that when you're not there, I guess it should have all been under lock and key. The judge knows that's not realistic. Anyone who's ever been in private practice knows that's the case. So, yes, you lock up the filing cabinets at night. Yes, you lock all the doors. You do all that stuff. But in the middle of the day, somebody walks by and takes pictures of things from people that you trust. How is that necessarily your fault? I just don't think it. Anyway, so Judge Frances Seagull, I know that's really her name, right? She concluded that the prosecutor had proven by a preponderance of the evidence, more likely than not, that the defense counsel was sloppy, negligent, and incompetent in their handling of the discovery. But once again, calling the pair negligent, incompetent, the judge determined that the prosecutor did not prove beyond a reasonable doubt that the defense team was acting willfully and intentionally in their so-called sloppy actions. Remember, the prosecutor thought that basically they thought that this was at the will of the attorneys. The attorneys cooperated in finding out who had taken the photos, how they were disseminated to the rest of the world. Anyway, so Frances Seagull agreed with the defense team's remarks that the pair weren't violating the gag order, as the prosecutor alleged, because that's right, they made the statements before the gag order went into effect. Now, who is sloppy, incompetent when the prosecutor knows that the statements were made before the gag order, but yet proceeded on pursuing that? I think the defense should ask for attorney's fees for having to take the time to defend themselves from such sloppy, incompetent, and negligent performance from the prosecutor. Anyway, we got a trial in a couple of weeks. There is a pretrial hearing set for May 7th where everybody's going to come together and have a big kumbaya there in Indiana to discuss the scheduling issues, because that trial is supposed to begin May 13th. And the judge says, well, you're given 2 weeks to do the trial, and I don't think any of your defense witnesses are really going to be able to be called. Sorry about that, defense attorneys. And we've got 2 weeks, and so that's all you got. The prosecution has endorsed 130 witnesses. Don't see how that's going to get done in 2 weeks, including the at least 3 days the judge thinks it's going to take to get a jury. Can you say cluster? Yep, you fill in the words. God, I wish it was going to be televised. But I think one of the reasons why the judge doesn't want to televise is she knows that she has helped create an absolute cluster. There you go.